Your life's work is about to be stolen by people you've never met. Right now, distant relatives and strangers are legally positioned to inherit your money, while your children watch helplessly. The legal system has hidden how $58 billion accidentally flows away from deserving families every year through 6 deadly estate planning mistakes. I'm Samuel Montrose, CPA and attorney at law with over 35 years of experience, and I'm about to expose each mistake costing families an average of $47,000 in misdirected inheritance. Mistake number 3 is a government loophole currently draining $12 billion per year from American families. And mistake number 1 is a single document error that hands 67% of your estate to complete strangers. Let's start with the most dangerous mistake that's silently poisoning inheritance plans right now. Mistake number 6 is what I call the zombie beneficiary trap. Mistake number 6, the zombie beneficiary predators. Picture financial vampires that never die. They attach themselves to your accounts decades ago, and they stay there forever, waiting to drain your wealth the moment you're gone. These aren't strangers breaking into your home. These are people you once trusted who are now legally positioned to steal everything from your family. Here's how this financial predator system actually works. Every retirement account, life insurance policy, and bank account you own has a beneficiary designation form buried somewhere in the paperwork. You filled these out years ago, maybe decades ago. You probably listed your spouse first, your children second, maybe even an ex-spouse or business partner. But life changed. People died, relationships ended, children got estranged, business partnerships dissolved, yet those zombie beneficiaries are still there, locked into the legal system, waiting to rise from the dead and claim your money. The shocking truth, 42% of Americans have never updated their beneficiaries after major life changes. That means nearly half of all inheritance money is flowing to people who were never meant to receive it. Let me show you how this predator feeds. When you die, your beneficiary designations override everything else. Your will doesn't matter. Your trust doesn't matter. Your family's desperate pleas don't matter. The zombie beneficiary automatically gets the money, even if they haven't spoken to you in 20 years. I've seen ex-spouses inherit entire retirement accounts, while current spouses get nothing. I've watched estranged children claim life insurance payouts, while devoted stepchildren are left empty-handed. I've witnessed business partners who cheated clients walk away with their victims' death benefits. The legal mechanism is simple but brutal. Financial institutions are legally required to follow beneficiary forms, no matter how old or irrelevant they've become. They cannot use common sense. They cannot consider fairness. They must hand over the money to whoever is listed, even if that person destroyed your family or betrayed your trust. Here's your immediate action step. This week, contact every financial institution where you have accounts. Request current beneficiary designation forms for everything: retirement accounts, bank accounts, life insurance policies, investment accounts, even employer benefits you might have forgotten about. Review every name on every form. If someone is listed who shouldn't inherit your money, change it immediately. This single action could save your family tens of thousands of dollars and prevent devastating emotional trauma. The average zombie beneficiary claim steals $47,000 from the intended family, but the emotional damage is immeasurable when children watch strangers walk away with their inheritance. Mistake number 5, the evolution of legal protection. Now, if you've already addressed your beneficiary designations, you're ahead of most people. But the next mistake shows how legal protection has evolved, and many families are still using outdated strategies that completely fail in modern courts. 20 years ago, attorneys recommended something called a living trust as the gold standard of estate planning. They sold it as the ultimate wealth protection tool. They weren't wrong about the concept, but they missed a critical implementation step that renders most trusts completely useless. Here's what happened in the legal evolution. Early estate planning focused on creating the trust document itself. Lawyers would draft beautiful, comprehensive trust paperwork. Families would sign everything: pay the fees, and feel completely protected. The problem? They never actually moved their assets into the trust. This created what I call the empty vault syndrome. Imagine building the world's most secure bank vault, but leaving all your money sitting on the kitchen table. That's exactly what an unfunded trust becomes: sophisticated legal paperwork that protects nothing because it owns nothing. The modern legal reality is harsh. If your assets aren't properly titled in the name of your trust, they don't belong to the trust. When you die, those assets go through probate just like you never had a trust at all. Your family faces the exact same delays, costs, and public exposure you tried to avoid. I recently reviewed a case where an $800,000 estate went to distant relatives instead of the intended children. The family had a perfectly drafted trust, but the house, the largest asset, was never deeded to the trust. It went through intestate probate, and the state inheritance laws sent everything to cousins the family barely knew. The good news: this is completely preventable and surprisingly simple to fix. Every asset you own needs to be retitled in the name of your trust. Your house deed should show your trust as the owner. Your bank account should be opened in the trust's name. Your investment account should be transferred to the trust. This isn't complicated legal work. Most of it can be done with simple paperwork and phone calls, but it must be done systematically and completely. Your action step is creating an asset funding checklist within 30 days. List every asset you own: real estate, bank accounts, investment accounts, business interests, valuable personal property. Then systematically transfer ownership of each asset to your trust. The financial impact is enormous. Proper trust funding can save families an average of $58,000 in probate costs and protect assets from creditors, divorcing spouses, and legal predators. Mistake number 4. The validation your gut feeling was right. If you've ever felt like the financial system has hidden traps designed to catch regular people, your instincts were absolutely correct. The next mistake proves that joint ownership, something banks and attorneys promote as simple and convenient, is actually one of the most dangerous wealth transfer traps in the legal system. Let me share what happened with one of my clients, Margaret Chen. She came to my office feeling frustrated and suspicious about her financial advisor's recommendations. He kept pushing her to add her business partner as joint owner on her personal accounts for convenience and business efficiency. Something felt wrong to Margaret, but she couldn't articulate why. The advisor made it sound so logical. Joint ownership would allow business decisions to be made quickly. It would avoid probate. It seemed like smart financial planning. But Margaret's gut was warning her about something the advisor wasn't explaining. Joint ownership doesn't just provide convenience, it creates automatic inheritance rights. The moment you add someone as joint owner, you're giving them legal claim to the entire asset when you die, regardless of what your will or trust says. Here's the hidden mechanism that financial institutions don't publicize. Joint ownership operates under something called right of survivorship. This means when one joint owner dies, the survivor automatically owns everything. It doesn't matter if the deceased wanted their children to inherit. It doesn't matter if the joint ownership was only meant for convenience. The law is absolute. The survivor gets it all. In Margaret's case, adding her business partner as joint owner would have meant he'd inherit her house, her savings, and her investment accounts when she died. Her children would have gotten nothing from those assets. Worse, if the business partner had financial problems, creditors could have seized Margaret's personal assets to pay his debts, even while she was still alive. This joint ownership trap catches thousands of families every year. Parents add children to bank accounts for convenience, not realizing they're creating inheritance issues if that child dies first or gets divorced. Business partners share account access, accidentally giving each other rights to personal wealth. Elderly people add caregivers to accounts, unknowingly turning hired help into major beneficiaries. The legal precedent is crystal clear. In a landmark case, the Supreme Court ruled that joint ownership creates indivisible property rights. This means you cannot partially revoke someone's joint ownership. Once they're added, they own the asset as much as you do. Your immediate action is reviewing all jointly owned assets. Look at bank accounts, investment accounts, real estate deeds, and business interests. If someone is listed as joint owner who shouldn't automatically inherit your share, you need to restructure ownership immediately. The alternative is setting up authorized user access instead of joint ownership. This gives someone permission to access accounts and make transactions without creating inheritance rights. Most banks and investment companies can set this up quickly with proper documentation. The financial stakes are significant. The average joint ownership mistake transfers $73,000 to unintended recipients. But beyond the money, it validates what you probably suspected. The system has hidden traps that benefit institutions more than families. Mistake number 3, the international perspective on government control. Now here's where it gets really interesting, and this connects to that $12 billion government loophole I mentioned earlier. Most Americans don't realize that our country has one of the most aggressive government inheritance systems in the world. Other nations have evolved legal frameworks that prioritize family choice over government formulas, but we're still trapped in an antiquated system designed to transfer wealth to distant relatives. Let me explain how this works by contrasting it with international legal practices. In many European countries, families create formal wealth transfer documents that clearly establish inheritance priorities based on relationship closeness and family contribution. The government respects these family decisions and rarely interferes with private wealth distribution. But in America, if you die without a will, state governments immediately seize control of your wealth through something called intestacy laws. These aren't gentle guidelines, they're rigid formulas that prioritize blood relatives over chosen family, regardless of actual relationships or emotional bonds. Here's the mechanism that's draining $12 billion per year from American families. Each state has predetermined inheritance hierarchies that completely ignore family dynamics. The typical formula gives everything to your spouse first, then to children, then to parents, then to siblings, then to more distant relatives. But here's what makes it truly shocking. These laws treat all relationships as equal. A devoted friend who cared for you for decades gets nothing. A stepchild you raised from infancy gets nothing. A sibling who supported you through every crisis gets the same inheritance as a sibling who abandoned the family 30 years ago. I've seen families torn apart when devoted caregivers watch estranged relatives claim inheritances. A woman spent 5 years caring for her stepfather, managing his medical care, handling his finances, and providing daily support. When he died without updating his will, state law gave everything to his biological children who hadn't visited in over a decade. The international comparison is stark. Japanese families use formal ceremonies to declare wealth transfer intentions, which carry legal weight even without complex documentation. German families can create simple preference statements that override state formulas. Even Canadian provinces give courts more flexibility to consider actual family relationships over technical bloodlines. But American intestacy laws are designed around an outdated concept of family structure that doesn't match modern relationships. They assume that biological relatives automatically deserve wealth more than chosen family members who provide actual care and support. The financial mechanism is particularly cruel. When the state applies intestacy laws, they also impose additional costs. Court supervision, administrative fees, legal requirements, and mandatory waiting periods can consume 20 to 30% of the estate value before any inheritance is distributed. Your action step is creating a basic will within 60 days. This doesn't need to be complex or expensive. A simple will that clearly states your inheritance preferences immediately overrides state intestacy laws and puts you back in control of wealth distribution. Even a basic will can save families an average of $62,000 by avoiding intestacy proceedings and ensuring inheritance goes to chosen recipients rather than distant relatives selected by government formulas. Mistake number 2, the future you deserve to create. Let me paint you a picture of the financial security you could have 6 months from now. Imagine waking up every morning knowing your wealth is completely protected from every legal loophole and inheritance trap we've discussed. Picture your children growing up with the absolute certainty that your life's work will benefit them, not strangers. Envision the peace of mind that comes from mastering the legal system instead of being victimized by it. This vision becomes reality when you avoid the next mistake, which is one of the most overlooked wealth transfer traps in modern America. It's called cross-state inheritance confusion, and it's silently undermining estate plans for millions of families who don't even realize they're vulnerable. Here's the empowering truth about how this works. Every state has different inheritance laws, probate procedures, and tax requirements. When you move from one state to another, your existing estate planning documents don't automatically update to match new legal requirements. This creates dangerous gaps in protection that can redirect your inheritance to completely unintended recipients. The mechanism is more complex than most people realize. States have different definitions of community property, different tax exemptions, different probate procedures, and different intestacy formulas. A will that works perfectly in California might create major inheritance problems in Texas. Trust documents that provide complete protection in Florida might leave assets vulnerable in New York. I recently reviewed a case that shows the devastating impact of this mistake. A successful businessman lived in California for most of his career and created comprehensive estate planning documents designed to protect his family's wealth. When he retired, he moved to Texas for the lower taxes and better climate. He never updated his estate documents to comply with Texas law. When he died, his California-based estate plan triggered Texas inheritance procedures that he never intended. Assets that should have gone to his children were distributed according to Texas formulas. His family lost over $200,000 because the legal documents weren't aligned with the state where he actually lived. But here's the empowering part. This is completely preventable with proper planning. Every time you relocate to a different state, you have the opportunity to optimize your estate plan for better protection and tax advantages. Some states offer superior asset protection. Others provide better tax benefits. Some have more efficient probate procedures. The key is conducting a state-specific estate plan review within 6 months of any relocation. This isn't about starting over. It's about adapting your existing protection to work optimally in your new legal environment. Picture yourself 12 months from now, having relocated to your ideal retirement state with estate planning documents perfectly designed for that location's laws. Your wealth is protected by the strongest asset protection statutes available. Your taxes are minimized through state-specific strategies. Your probate procedures are streamlined for maximum efficiency. Your action step is scheduling a state-specific estate plan review anytime you relocate. This should include updating wills and trusts to match local requirements, reviewing beneficiary designations for state-specific rules, and optimizing tax strategies for your new location's laws. The average cross-state inheritance trap costs families $84,000 in unnecessary taxes, legal fees, and misdirected assets. But families who proactively address this can actually improve their wealth protection while saving significant money. The future you can create is one where geographic moves enhance your financial security instead of undermining it, where state-specific strategies multiply your wealth instead of depleting it, where your family inheritance is optimized for the legal environment where you actually live, not where you used to live. This level of financial mastery puts you in complete control of your wealth's destiny. You're no longer at the mercy of legal technicalities or state-by-state confusion. You become someone who uses the legal system strategically to build and protect generational wealth. But now, we need to address the most dangerous inheritance mistake of all. The one that hands 67% of estates to complete strangers through a single document error that most families don't even know exists. Now here's the ultimate climax, mistake number 1. This is the single document error that hands 67% of your estate to complete strangers, and it's happening to families right now while they're still alive to watch their wealth disappear. Mistake number 1, the guardianship wealth transfer trap. Picture this nightmare scenario. You become incapacitated from illness or injury. You can't make financial decisions anymore. But instead of your family stepping in to protect your wealth, a judge appoints a complete stranger to control everything you've ever earned. This stranger has legal authority to sell your house, drain your accounts, and charge massive fees for managing your assets. When you die, there's nothing left for your family. This isn't a rare tragedy. This is a thriving industry called professional guardianship, and it's legally draining billions of dollars from American families every year. These court-appointed strangers make their living by taking control of incapacitated people's wealth and slowly transferring it to themselves through legal fees and questionable financial decisions. The mechanism is brutally simple. When someone becomes incapacitated without proper incapacity planning, courts must appoint a guardian to make financial decisions. If family members aren't legally designated or if they disagree among themselves, judges often choose professional guardian strangers who make their living controlling other people's money. These professional guardians charge hourly fees for every decision they make about your wealth. They charge for reviewing your mail, paying your bills, visiting your property, consulting with attorneys, and filing court reports. The average professional guardian charges between $100 and $300 per hour, and they can justify almost any activity as necessary for your care. But here's the shocking part. They also have legal authority to make major financial decisions without your family's consent. They can sell your home to pay for care facilities. They can liquidate investments to cover their fees. They can make charitable donations in your name. They can even loan your money to their other clients or business associates. The professional guardianship industry generates over $4 billion per year in fees extracted from incapacitated people's estates. The average professional guardian controls 12 to 15 cases simultaneously, generating between $800,000 and $2 million in annual income by managing other people's wealth. By the time you die, professional guardians have often consumed most of your estate through fees, poor investment decisions, and unnecessary expenses. Your family inherits whatever remains after years of professional wealth extraction. But this entire nightmare is completely preventable with one simple legal document, a properly drafted financial power of attorney that specifically designates trusted family members to handle your financial affairs if you become incapacitated. Without this document, you're literally one accident or illness away from losing control of your entire life's work to profitable strangers who have no emotional connection to you or your family's future. Now you're armed with the complete truth about how the legal system redirects wealth away from families. Let me quickly recap the 6 deadly mistakes that are costing American families over $200,000 in misdirected inheritance. Mistake number 6, zombie beneficiary predators who automatically inherit despite being unwanted recipients. Average cost $47,000. Mistake number 5, unfunded living trusts that become useless paperwork when assets aren't properly transferred. Average cost $58,000. Mistake number 4, joint ownership confusion that creates automatic inheritance rights for unintended recipients. Average cost $73,000. Mistake number 3, ignoring state intestacy, laws that trigger government formulas prioritizing distant relative. Average cost $62,000. Mistake number 2, cross-state inheritance traps that invalidate estate plans when you relocate. Average cost $84,000. And mistake number 1, the guardianship wealth transfer that hands control to professional strangers who drain estates through fees. This one can cost families their entire inheritance. You now have 6 powerful legal shields that can protect over $200,000 in family wealth from being stolen by financial predators and legal loopholes. Now I want to hear from you. Which of these 6 mistakes hit closest to home for your family situation? Do you have your own story about inheritance money going to the wrong people, or family members fighting over assets that should have been protected? And what's your biggest fear about where your money might end up if something happened to you tomorrow? Drop your experience in the comments below, because your story could be exactly what someone else needs to hear to protect their family's wealth. Hit that subscribe button and ring the notification bell, because every week I release new videos packed with legal strategies that reveal how to protect your wealth from financial predators. Keep your money in your family's hands and ensure your life's work benefits the people you actually care about. Next week, I'm revealing the 4 legal phrases that, when missing from your will, automatically trigger these wealth transfer mistakes, including the one phrase that prevents 89% of contested inheritances. You won't want to miss that protection. Your financial future is completely within your control.